Zimmerman called police and was told not to pursue, but he didn't listen. He got out of the car, he followed Trayvon, and he had a gun. And moments later, Trayvon was dead. The defense will tell you that this is self-defense, but self-defense does not apply when you create the threat, when you doesn't listen to the police instructions, when you provoke a confrontation and pull the trigger. We, prosecution, carry the burden to prove that this killing was not an accident, it was a second-degree murder. The law defines second-degree murder as a killing that results from an act done with ill will, indifference to human life, and spite. And that's exactly what this was. You will hear from our witness, Rachel Gentle, the last person who spoke to the Trayvon Martin. She will tell you that he was terrified. He told her that he was being followed. She heard the panic in his voice. You will also hear from an expert, Simon, who is an expert psychologist who studied Zimmerman's behavior. She will explain you that how Zimmerman was driven by motivated reasoning, how he jumped to the conclusion based on the appearance of Trayvon Martin and not his actions. She will explain how Zimmerman's history of power-seeking behavior and a distorted view of justice created a dangerous mindset. We will show you that Zimmerman's calls history, how out of 46 calls to the police, the majority targeted the black males. Dr. Jenna Simpson explained in his affidavit number 101, statement number 101, where he said, these assholes always get away, not this person, but those, showing a clear racial generalization. Zimmerman chose to escalate, he chose to carry a gun, he chose to pursue, and all these choices killed Trayvon Martin. The defense will tell you that Zimmerman was attacked, that he feared for his life, but ask yourself, who created the situation? Zimmerman could have stayed in the car, he could have waited for the police. Instead, he became the judge, jury, and the executioner. Even if a struggle occurred, Trayvon was unarmed, he was a teenager. Zimmerman was adult, Zimmerman had the weapon, and Zimmerman had the choice. This is not just about what happened that night. This is about how and why it happened that night. Zimmerman's own words and actions shows that he was not trying to survive. He was trying to control. His actions reflect a pattern of bias, a dangerous sense of entitlement, a complete disregard for human life. At the end of this trial, you will have only one choice that reflects justice, accountability, and the law, to find George Zimmerman guilty of second-degree murder. Thank you.
All right, opening from defense.
Yes, Your Honor. Your Honor, before going for the openings, we have pre-trial motions. If you allow, may we proceed with our pre-trial motions?
Yes, you may.
Thank you, Your Honor. Your Honor, the defense respectfully moves this court to exclude any references to defendant's prior arrests or criminal recourse as prejudicial under La Rule 403. As well as, Your Honor, the defense... As well as, Your Honor, defense additionally requests the court to stipulate the case to be solely tried on the basis of self-defense, excluding any argument based on stand your ground, immunity, or mental incapacity. Your Honor, we request the court to refer and utilize all relevant exhibits during our both direct and cross-examinations, as well as during our reference to sworn affidavits. Your Honor, Furthermore, we also seek permission from the court to display our screen share while referring these exhibits during our examination and arguments. Your Honor, we further also seek permission from the court to uh, leave us to read from or reference the affidavit of Rachel Gentle and Jenna Simmons during cross-examination and during cross-examination and our arguments were relevant. Thank you, Your Honor.
Okay. That's pre-trial, right?
Yes, Your Honor. That was a pre-trial motion.
Okay. Any other pre-trial matters from the prosecution?
Now we are going to have the direct examination of our first witness.
Oh, wait. I don't think they've done their opening yet because
Yeah.
they just
Yes.
did the trial matters. Defense, you can proceed with their opening.
Thank you, Your Honor. May I please the court? Your Honor, my name is Hassan Ali along with my co-counsel Aliba Tariq, and today we represent George Zimmerman, a man who on that rainy evening acted not out of malice but for his self-defense to save his life where it was a necessity to save his life. George Zimmerman is not a guilty of murder because what he did was a lawful defense. George Zimmerman is not a superhero, Your Honor. He is just a man who volunteered to protect his neighborhood, a man who wanted to save his community, his wife, his other neighborhoods. Sorry. Your Honor, George Zimmerman answered the call of civic duty not because he wanted power, but because he wanted safety for neighbors, his wife, his community, and everyone else around him. Ladies and gentlemen of the jury, imagine this. It's raining in Sanford, Florida. It's dark. It's quiet and retreat at Twin Lakes. Lakes is a neighborhood on edge after a string of burglaries. George Zimmerman, a neighborhood watch captain, not a police officer, not a vigilant, but a volunteer, is doing what he is done countless times before, watching out for his neighbors. While watching out his neighbors, he sees a hooded figure walking slowly between buildings, imagining not lingering, not heading directly to any home. George does not recognize him. He calls the non-emergency police as instructed by neighborhood watch training. Your Honor, it's not confrontation initiated by George Zimmerman. What happens is an ambush. A teenager named Trayvon Martin, unknown to George, attacks him without warning, pins him down, and slams his head against pavement. In that terrifying moment, Your Honor, George Zimmerman had two choices. Either he may either he may just face deadly consequences of brutal beating, either he may act for that as a self-defense to defend his life, and he chose the second option. He He acted just to save his life, not out of hatred, not the malice, but with the fear of any of us would feel with our head on the concrete and someone on top of us. Your Honor, the prosecution charges Zimmerman with a second-degree murder, and they must prove that Zimmerman killed Trevor Martin with a deliberate malice and indifference to human life. But the evidence will show that this tragic incident was not a murder. It was not an act of racial aggression. It was a self-defense, plain and simple. Mr. Zimmerman did not seek confrontation. He did not seek to kill. He sought only to survive. Your Honor, it was also held in a case of Bureau of Software Co. versus Mars Investigation 1998 LOCA. It does not permit parties to use their experts as weapons in trial by ambush or unfair surprise. Experts are strictly prohibited. from testifying on direct or redirect examination about any opinion or conclusions not stated in their report. Your Honor, you will hear from Mr. Zimmerman himself. He will tell you under oath that how he feared for his life was on 26 Feb 2012. You will hear you will hear how he reported Trayvon Martin to the police and was told to stay in his vehicle. But as he turned back towards his car, Trayvon Martin emerged from the darkness, confronted him, and attacked. He will explain how, in desperate movement, with his head being slammed against the concrete, he drew his legally owned firearm and discharged it once to stop attack, not to kill, to survive. His story is not just a consistent, it is corroborated by injuries, the 9-1 tape, and forensic evidences also. Your Honor, you will also hear from Sanford Police Chief Billy, a seasoned law enforcement officer with no allegiance to George Zimmerman, but only the facts. Uh, Your Honor, Chief Billy will walk you through the timeline of events, the 9/11 calls, and the most importantly, the physical and forensic evidences. He will confirm that Martin was not armed, but more critically, he will confirm that Zimmerman had injuries consistent with being attacked and pinned down. Chief Lee will also testify that there was insufficient evidence to arrest Zimmerman initially, not because of bias, but because of evidence supported by self-defense. But here is let's look at evidences. What evidences show? Firstly, George called the police, proving he sought help, not confrontation. Secondly, he carried a firearm legally, as Chief Willie will confirm a right he held as a citizen and a watch captain. Thirdly, he was on his way back to his car when Martin turned and attacked him. Fourthly, George will testify he fired one shot, not out of spite but out of fear, as Martin battered him on the ground. Your Honor, George did not act with malice aforethought, as second degree murder requires. He acted with fear, with description, and with instinct to live. Florida law is clear about that a person has authority to use deadly force if they reasonably believe it's necessary to prevent imminent death or great bodily harm. George did not need to wait until his skull was cracked or his life was slipping away. He did not need to be a perfect victim. He just needed to fear for his life reasonably, and he did. Your Honor, the law does not require George Zimmerman to prove his innocence. The burden of proof rests entirely on the prosecution side, and that burden is high beyond a reasonable doubt. The evidence in this case will not rise to that level. In fact, the evidence will show that the only person who knows what it felt like to be attacked at that night, the only person who feared for his life was George Zimmerman, not Morton. We do not come before you to deny the pain and sadness of a young man's death, but we do come to assert a fundamental truth. Self-defense is not a murder, and in this trial, when this trial ends, we are confident you will return the only just verdict under the law, not guilty. Thank you, Your Honor.
All right. Wonderful. Prosecution first witness.
Now we will be having a direct examination of a psychology expert, Miss Jana Simon. So may it please the court. Dr. Gina Simon, can you briefly describe your professional background in psychology?
Hi, sure. I earned my bachelor degree in psychology from San Diego State University and my doctorate from the United States International University. I have worked ever since as family and marriage counselor at Sheren Family Service, where I focus on anger management, emotional regulations, and neuropsychology. I also authored Freshly Brain and contributed to platforms like Psychology Today and Forbes.
Okay, what materials did you review while preparing your opinion for this case?
I reviewed Exhibit 2, 3, 6, and 8 along with sworn statements from George Zimmerman, Billy, and Frank David. I also analyzed public interviews, police records, and my own previous writing on racial profiling and emotional behavior under stress.
Okay, can you explain what motivated reasoning is and how it relates to Zimmerman's behavior?
Motivated reasoning is when people subconsciously twist facts to fit their emotions and expectations. Zimmerman likely saw Trayvon as a threat not because of real danger, but because he emotionally needed to justify his suspicions. That emotional shortcut is called fast thinking, and in this case, his decisions were somehow relied on fast thinking.
Did you observe sign of implicit or subconscious bias in Zimmerman's behavior?
Yes, Zimmerman had a pattern of calling police for black males. 4 out of 6 public calls involved black boys. That's a clear sign of implicit prejudice, that is, subconscious bias, formed from repeated racial stereotypes and past experience, not by conscious racism.
Okay, based on his past, did you see a behavioral pattern in Zimmerman that may have influenced the shooting?
Definitely. Zimmerman had a documented history of anger control issues. He attempted to attack a, he previously attempted to attack a police officer in defense of a friend and was accused of abusing his fiancée in 2006. He also sought power by trying to become a police officer, and when rejected, created his own neighborhood patrols, where he gave himself authority.
Point to be noted, my lord. Zimmerman had a power-seeking behavior. From Ms. Simon, from a psychological standpoint, how does anger affect decision making in stressful situations?
Anger overrides logic. It limits a person's ability to pause and reflect. Zimmerman's emotional state, including frustration and skewed sense of justice, likely led him to act impulsively, ignoring police instructions and escalating the situation.
Dr. Simon, what is your professional conclusion regarding George Zimmerman's state of mind that night?
Based on the evidence, Zimmerman acted from a place of frustration, power-seeking, and emotional bias. He saw Trayvon Martin not through objective reasoning, but
Objection, Your Honor.
On what grounds?
Hearsay, Your Honor.
Can you elaborate?
Your Honor, they have not showed any evidence or exhibits to the court.
Okay.
Okay.
Defense counsel, what was her statement again? Can you repeat?
Your Honor, they have not showed any exhibits or evidences to the court.
Oh no, I mean, what was the witness's statements? That's hearsay.
She told about the George Zimmerman's past background, etc. वगैरह. That was explained in exhibits.
I'll overrule. Proceed.
Dr. Simon, what is your professional conclusion regarding George Zimmerman's state of mind that night?
based on the evidences, Zimmerman acted from a place of frustration, power-seeking, and emotional bias. He saw Trayvon Martin not through objective reasoning, but through fear, implicit prejudice, and motivated reasoning. I firmly believe Zimmerman initiated the conflict and was the aggressor, not the victim.
Thank you, Dr. Simon. Member of the jury, what you just hear is that this was not a man trying to defend himself. This was a man driven by a need to dominate, fueled by years of frustration and triggered by his own prejudice, not any real threat. Thank you. That's all from my side.
Okay, cross. Cross from defense.
May it please the court, may I start with my cross-examination?
Yes, you may.
Thank you. So, Miss George Zimmerman, you were hired by the state of Florida on this case, right?
Right.
And you heard of this case online through web.
Yeah, in start, yes.
And you decided to research on the web resources.
Yes. In start, yes, it was.
Okay, and you write your about regarding this case.
Yes, few articles.
Okay, and after that article, prosecution contacted you for giving a testimony.
Yes.
Mrs. Simon, Miss Simon, does you appear before a court in any criminal case?
No.
So, Mr. Simon, although you are not appear before in any criminal case, did you have any history in which you assess the cases like this?
No.
And your expertise lies in therapy and counseling, right?
My expertise lies in family counseling, yeah, right. But it also deals with the issues like
Okay, I got your
anxiety.
point.
Okay.
But you have no expertise regarding forensic psychology and criminal behavior profiling.
Objection, Your Honor.
On what grounds?
Leading questions.
No.
Well, leading questions are always allowed in cross-examination. Let's proceed.
Thank you, Your Honor.
With all due respects, may I?
Briefly.
Our co-counselor just required to ask that the defense attorney second is not asking a leading questions. So they are again and again stepping forward for non-leading questions. That's all.
Oh, prosecution attorney, are you objecting that they're not asking leading questions or that they are asking leading questions?
They are not asking leading question, my ladyship.
Okay. First of all, please. So first of all, I forgot your name. Sorry.
Aliba.
Right. Wait. The female prosecution attorney. What's your name again?
My name is Aliba Tariq.
Oh, the prosecution attorney.
Faiqah Khalid.
Okay, so you're supposed to be the one to argue, not your co-counsel. Just to keep that in mind, because you're supposed to be the one to argue. And second of all, there isn't a specific rule that says that in cross-examinations you're only supposed to ask leading questions. It's only suggested to ask. It's only that asking leading questions in cross-examination are better off. So I'm gonna overrule the objection. So let's move on.
Your Honor, may I proceed further?
Yes, you may.
Thank you, Your Honor. So, Miss Simon, have you ever met with George?
No.
So, do you have conducted any personal interview with George regarding this case?
No, I didn't met George directly. However, I analyzed his documented behavior and statement using accepted psychological theory.
Okay. And you never met with George, but you diagnosed him a desire for power and racist. Am I right?
Yeah, I told this because of his actions
Thank you. I
regarding.
got your answer. So, without direct psychological evaluation, is it speculative to label someone's aggressive or desire for power? Do you think so?
But in psychology, we use the documented things for that purpose. So I judge on that basis. The psychological theories are also applied.
So, in your post, you label him a racist without doing a formal investigation.
Yeah, because psychological theory don't work through the tools, physical tools.
Don't
They
don't you think that without meeting with the person you are claiming that he is racist, it is called defamation?
Objection, Your Honor.
On what grounds?
Speculation.
Can you elaborate?
Yeah. It's not based on facts. A defense attorney is asking about the personal opinion by saying, "Don't you think that this is speculation?"
Defense attorney, can you please repeat your question, just so I can make
Yes, Your
sure,
Honor.
and also
I'm
please.
saying that Okay, I'm saying that
Yeah.
without investigating formally, you prove him racist. It is defamation, right?
Okay, I don't think that was the question. Please just restate the question that you just asked.
In in post, you label him a racist, but without doing any formal investigation. Don't you think it is a defamation without assessing?
Okay, defense attorney response to the objection. Any response?
Yes, Your Honor. Okay, Your Honor, it is not based on speculative. I'm just because as an attorney, I have no the law. So that's why I am clearing the witness that it is a defamation without assessing. You are labeling someone or you are making allegation on someone. That's all.
Response from prosecution?
My ladyship, she is a psychiatrist and she is not supposed to answer the legal questions.
I will overrule the objection. I'll just briefly explain why. So first of all, speculation is when you're testing towards someone else's state of mind. So for example, if I say someone else they're angry, that's speculation because I actually don't know if they're angry or not. But like in this case, it's not speculation as the defense attorney, her question isn't towards anyone else's state of mind. It's simply asking the expert whether or not she thinks that way. So yeah, let's proceed.
Thank you, Your Honor. So, Miss Simon, without any concrete evidence, you had already made up your mind that the Mr. George is guilty. Am I right?
But there is psychological theory applied to this document, and they are applied to document also when there is no personal interview. It's a psychological way.
Well, Miss Simon, don't you think do you agree that objectivity is crucial in evaluating the character of the person?
Sorry, repeat the question. I didn't get the point.
Would you agree that objectivity is crucial in evaluation?
Can you rephrase? I can't understand.
I am saying that don't you think that the objectivity is crucial in evaluation on just on a theoretical work?
As far as I know, it's an accepted way to analyze the behavior of a person through documented things. That's it.
Point to be noted, Your Honor, with the witness without meeting with the accused person, just on a theoretical base, making assessment and speculations. I will proceed with my next question. Your pre-existing biasness undermines your objectivity. Why?
Sorry? Pre-existing?
I'm saying your pre-existing biasness undermined your objectivity. I'm right?
Objection,
Sort
Your
of.
Honor.
What grounds?
Argumentative objection. She is
Oh.
trying to provoke the witness and not to elect the facts.
Response, defense attorney?
Yes, Your Honor. Your Honor, already witness stated that he done through the documents and through the theoretical work assessed the witness. So I am saying that without meeting your pre-exist biasness undermine your objective. Is it true?
Okay, response from prosecution?
Your Honor, Miss Simon is an psychology expert, and how can she be biased? She is hired by the court for her expert opinions and not for her biasness. She is impartial. She is not biased. She is giving opinion on the basis of the evidences that provided to her, and not for her biasness.
Okay, I will overrule the objection. So, because you are allowed to talk about a witness's possible biasness in cross-examination. That's allowed in court. So let's proceed.
Thank you, Your Honor. So, Miss Simon, you said all people have implicit biasness. Would you include yourself in it?
Implicit biasness is like due to some childhood traumas or due to some previous experiences that leads toward that. And
Okay, Miss Simon, I got your answer. So everyone has implicit biasness as per your opinion, as per your research.
no, not everyone. The one with background.
So we don't know everyone's background, so maybe it's possible. So it's possible your implicit biases influenced your conclusion on this case.
Sorry?
I'm saying that it is possible your implicit biasness influenced your conclusion regarding Mr. Zimmerman.
As for my implicit biasness is not judged in the court. I'm not here for that. But as far as Zimmerman's implicit biasness is concerned, his previous behaviors do exist in exhibits. The previous history.
So, Miss Simon, you mentioned that Martin have in his blood the elements of THQ. Am I right?
Yes.
And maybe this content can play a role in violence, right?
Sort of.
So you are agreeing. Thank you. So I'm saying, is it possible that Martin start violence due to this intoxication?
This intoxication was found in some nanograms, so it might not affect the brain.
So, Miss Simon, you are aware of the fact that he is under 18 and teenager boy?
Yeah.
Thank you. Your Honor, no more further questions. Thank you.
Okay, any redirect of this witness?
Shall I proceed for redirect questions to Ms. Simon?
Yes, you may proceed.
So, Dr. Simon, even though you didn't meet Mr. Zimmerman, is it standard in your field to analyze behavior using documented evidence?
Yes, documented based analysis is routine in clinical and forensics psychology when direct evaluation is impossible.
Okay. Is your analysis based on established psychological principles, not personal opinion?
Yes, they are based on established psychological opinions.
And you never claim to know exactly what Zimmerman was thinking, only how his behavior aligned with emotional decision making, correct?
Yes.
Okay, that's all from my side.
All right, any recross?
Yes, Your Honor.
Okay, proceed. Please proceed.
So, Mr. Simon, you stated again in your re-examination that you are not making a conclusion that Mr. Zimmerman is emotional on that night or fast or slow thinking. You are saying that just according to the psychology, it could be happen. Am I right?
Yeah, it is backed by fast thinking as well.
So, Miss
Correct.
Simon, is it a possibility that night Mr. Zimmerman is not acting like that and he's acting in a self-defense? Is it a possibility?
Um,
Right.
yeah, there can be possibility as well, but
Thank you. Thank you, Mr. Simon.
fine.
Thank you, Ms. Simon. I got your answer. Point to be noted, Your Honor. There it is a possibility that Mr. George Zimmerman is acting in a self-defense, not thinking like that, that our expert witness, that is not expert as my opinion, is saying. Thank you, Your Honor.
Any redirect? Is that no? Any redirect?
Okay, yeah. So, Miss Simon, you agree your conclusions are not based on any peer-reviewed research specific to this case, correct?
Objection, Your Honor.
On what grounds?
Attorney is trying to lead the question, asking the leading question during that direct examination.
I will sustain the objection. Prosecution attorney, please rephrase your question that's into a form that's not leading. Thank you.
You mentioned that your conclusions are not based on research specific. So, what do you say about this?
Okay. They were not based on like my specific case. Sorry, the specific case specific to this case, my theories are not peer reviewed, but the theories I use to end up this judgment in affidavits, I use the theories that are peer reviewed and psychologically accepted
Okay.
theories.
So, everything you know about this case comes from documents provided to you. What's your personal investigation on it on the basis of psychology?
Sorry, can you repeat, please?
Sure. Everything you know about this case comes from documents provided to you. What's your personal analysis on it?
They are document based, and my personal analysis is totally provided in affidavit as well.
Okay. That's all from my side, Your Honor.
All right. Any recross?
Yes, Your Honor.
Oh, yes. Wait, no or yes?
Thank you. Yes, I want.
Okay, then you may proceed with your recross.
Okay, thank you, Your Honor. So, Ms. Simon, you stated that you reviewed the documents or evidence that is provided by the prosecution and you analyzed this. And as per your opinion, it could be possible that Mr. Zimmerman can be. It can be a racist or all that, and it would be a possibility that Mr. Zimmerman is acting as a self-defense. Am I right?
Yes.
Thank you, Your Honor. So, witness is admitting that it could be a possibility that self-defense still exists and doubt is still exists in the testimony of witnesses. Thank you, Your Honor.
Okay. I'm assuming there's no redirect, right?
Yeah.
All right, okay. Great. Let's move on with our second witness from the prosecution side.
With the kind permission of your ladyship, may I proceed?
Yes, you may.
I'm here on the behalf of prosecutions, and I'm here the direct examinations with the Rachel Janital. Miss Janital, can you hear me?
Yes, I can hear you.
Okay. Good morning, Ms. Janital. I would like to ask you some few questions regarding the incidents on February 26, 2012, and your relationship with Trayvon Martin, right? And I appreciate your cooperation as we walk through this together. If at any point you need clarification, please let me know. Are you comfortable?
Yeah, sure. Yeah, sure. Why not?
Sure. So it's a humble request from the court. May I proceed the direct examination with Ms. Janital?
Yes, you may.
Um, please, please introduce yourself to the court, Ms. Janital.
My name is Richard Janital. I was born on Miami to Hayatan. I'm 19-year-old. I belong to a middle class family, and my parents are from Hayatan as well. I can speak Korean, Spanish. I take my educations very seriously, and I got 3 GB in my academics.
Okay, I got you, Miss Janital. How do you know Trayvon Martin? What was your relationship with them?
Trayvon was one of my very close friends. You can call it more than a friend. We met in second grade. He was one of my best friends. Yeah.
Okay, got you. How would you describe Trayvon Martin as a person to the court?
Trayvon was very kind, funny, and that type of guy who can make smile anyone, even in a
Objection,
very
Your Honor.
worst day.
On what grounds?
Hearsay, Your Honor.
Okay, elaborate.
Your Honor, he is trying to say Martin was a good person without any evidence or without any concrete evidence, exhibits, etc.
With the kind permission of your ladyship. With the kind
Response.
They are just assuming facts, Your Honor.
Response from prosecution.
with, sure, make the kind permission of your ladyship. The Miss Rigid genitals are supposed to be here, are required to just through what she mentioned in her affidavit. That's all, my ladyship. That's all.
Okay, I will overrule the objection. I'm just gonna explain a little bit. So first of all, hearsay are out-of-court statements made for the truth of the matter asserted. In this case, Rachel Gentile, he isn't referring to anything out of the court, any statements out of the court, so it's not hearsay. There is another objection to this, but let's move on. I'll talk about it.
Much obliged, your ladyship. Without further delay, may I proceed?
Yes, you may.
Was Miss Genital, can you hear me?
Yeah, I can hear you.
Was Trayvon ever aggressive or violent with others?
No, people misunderstood him because of some mistakes, but he wasn't violent. He had a good heart. He is such kind of person. I still remember an incident where the kids are making fun of my underparts, and Trevor and I was crying and went to the home, but Trevor came to me next day and he said to me that don't worry, whatever you are the best. I still remember that incident.
I would like to draw the kind attention of your ladyships towards the personality of Trayvon Martin's, how, and he was. My ladyship, my ladyship, who does not mess up in their teenage year? My ladyship. That's all. Yeah, and you mentioned he volunteer. Can you elaborate?
Yeah, Trayvon was he was always
Objection,
trying
Your
to.
Honor.
On what grounds?
Yeah, Your Honor, lack of evidence. They have not shown exhibits of wearing.
Sorry, can you repeat your ground? I didn't really catch her.
Your Honor, they have not showed any exhibits of volunteership.
May I proceed?
Response from prosecution?
With the kind permission of your ladyship, as I already said that Miss Rachel genitals are required to be here, to just supposed to be here to through what she mentioned in her affidavits. So I was just supposed to ask where she volunteer. So that's where he volunteer. That's all. And exhibit number, I will show the exhibits where he volunteer as a that's all concessions. Volunteer or sign up if it is clear to you, my court.
Your Honor, he did not submit
That's
these
all
exhibits before
volunteer.
questioning the witness.
All right.
I hope the co-consular attorney didn't get what I actually asked from Trayvon Martin.
I think what the defense counsel is saying right now is that you're not allowed to talk about an exhibit before entering it, and in this
Yes,
case,
exactly.
your is in fact talking about how Trayvon Martin is volunteering. However, you guys did
Exactly.
not screen share the exhibit or enter the exhibit. In this case, I will sustain the objection. If you guys want to talk about how Trayvon Martin is voluntarily, you need to screen share the exhibit and enter them.
Sure, your ladyship. Kindly move to the exhibits. My ladyship, without further delay, may I?
Wait, I don't see the exhibit on the screen.
Okay. Humbly request to this attorney one. Kindly just move to the exhibits number. Exhibit number. Can you hear me, attorney one?
Yeah, I can hear you. I have shared the screen.
And move to the exhibits kindly.
Which exhibit?
Exhibits the where he volunteer. Exhibit number as I early mentions to the just where he was. Exhibit number 9. See, my ladyships, how he was so active and concession stand
Objection, Your
volunteer.
Honor.
So,
Objection, Your Honor.
About grounds?
Lack of foundation, Your Honor. He did not recognize this exhibit from the witness.
Right. Before entering the exhibit, please lay some foundations.
we have foundations regarding that. My ladyship, I just asked about the volunteers, right? About his past volunteer acting Trayvon Martin. That's it.
Okay. Response from defense?
Your Honor, before entering this exhibit into the court, he even did not ask from the witness, is it your concession voluntary sign-up sheet? And this shows the lack of foundation.
Okay, please, prosecution attorney, please ask some foundation questions. For example,
I'm doing
Um,
my ladyship. I'm just asking the foundation questions. Why I'm supposed to be ask like a foundation question? There will be more messy to the my witness as well.
okay, then, okay, please proceed with your foundation questions.
Sure. Miss Rachel,
Yeah,
were you on the phone with Trayvon Martin on the night of February 26, 2012?
yeah. As usual, I was on the phone at that time.
Okay. And what was he doing during the call?
He was going to buy some
Objection, Your
candies.
Honor. Objection, Your Honor.
On what grounds?
Your Honor, leading question. He is leading the witness.
It's not leading question, my ladyship. I was just asking
Can
the
you
incidents,
restate your
what
question?
actually they face at that hall, what actually the Trayvon Martin faced that hall caused. The Rachel Genital was the only one person who with Rachel genitals, even on virtually.
Wait, prosecution attorney, can you just repeat the question that you just asked?
I was asking what was he doing during that call. That's it.
Can
The defense attorney, anything?
Your Honor, they are continuously showing lack of foundation in every question, and he is leading the witness.
My ladyships, my co-counselor on the behalf of respondents show their own lack of foundations. I'm asking on just on the basis of affidavits, not out of the affidavits and not out of that kind. That's it.
I will overrule the objection for now.
Much
Let's
obliged,
proceed.
my ladyship. Without further delay, Miss Rachel, can you hear me?
Yeah, I can hear you.
What was he doing during the call, my lady, Miss Rachel? You didn't answer.
Actually, we always spend more time together. At that time, he was also on call during that incident happened. He went to buy some candies and walking towards his dad's home.
Okay, got you. Did anything unusual happen during the call where you were on the call? So you just, you just had some kind of some messy with Trayvon Martin?
Yeah, he told a man was following him. He said the creepy ass trapping keep following me.
Okay,
That's what he said.
okay. So my ladyship point to be noted, that's how the Trayvon Martin's scary from that kind of that person. So how did Trayvon sound at that moment?
I still remember he scared that how much he was. I'm sorry.
Okay, Rachel, take your time. You understand this is so difficult for you and emotionally. When you are ready, we will continue. And Your Honor, I respectfully request a brief recess for the witness, and she appear visibly distressed. And I believe she needs a moment to compose herself, if you allow.
All right, that's fine.
Okay, Miss Rachel, take your time when you're free, when you feel comfy.
It's okay. I'm fine now. I'll cooperate with the court. I'm so sorry. So sorry. I
Okay,
got emotional.
okay, got you. And
And also, wait, also, are we still talking about exhibit 9? If not, we can take down the exhibit.
we are go further, my ladyship, without further delay.
Are we still talking about exhibit 9 though? Because like it's still screen
No
sharing.
ladyship, no ladyship.
Okay, then you can take it down.
Okay, thank you. Much obliged, my ladyship.
No problem. Let's proceed.
Thank. Without further, Rachel, can you hear me?
Yeah, I can hear you.
Okay, yeah. Did you give him any advice at the horror of incident?
As I was in call, and at that time, that incident, the male started following him. I advised him to run very fast and run away from him. He said he was going to run. Then the call got bad, and he was breathing very heavily, sounded out of his breath. I still remember that.
God, sound of a breath, my ladyship. What happened next after that?
After that, he
Did,
lost the guy, but then the man came closer to him suddenly. Trayvon said, I still remember, if I'm not wrong, he said that, what you do following me for? And then I had another voice which is already sounded, say, what you doing around here? It could be these words.
okay, did you try to call him
Objection,
back?
Your Honor.
Did
Objection,
you
Your Honor.
On what grounds?
There's no concrete evidence, Your Honor.
on which
He
one?
said it could be. He said it could be.
My
There's no concrete evidence.
It's a
Defense attorney,
misunderstanding. It's a totally misunderstanding, my ladyships. Mr. Rachel just trying to express her emotion here, that what she faced at that hole and the time of incidents, my ladyship, not further and not more.
Your Honor, Your Honor, witness is guessing what he does not know. This is clearly a speculation.
okay, defense attorney, can you please repeat what the witness said? Defense attorney, can you actually, Miss Genital, Mr. Genital, can you repeat what you just said?
I said that as I was in call, I said that the men started following him, and when he came close to him, and Trayvon said that, "What you two following me for?" Then the call got bad. I mentioned that he said that the guy which he's following, who was following, he said that, "What you doing around here?" I said these words.
That's all, your ladyship, from the witness.
Okay, any response, defense attorney? Defense attorney? Mr. Hassan Ali, any response?
Your Honor, sorry, I had an internet issue. Can you repeat?
Oh, so I just asked the witness to repeat his answer. Do you have any response?
Yes, ma'am.
Okay.
Your Honor, this is the clear speculation where he says that he is lying about things. There's no concrete evidence to him for proving his points.
Okay, I will overrule the objection. Let's
Much
proceed.
obliged, my ladyship, much obliged. Without further delay and due to shortage of time, may I proceed with Ms. Rachel Genitals, our direct examination we have already started.
Yes, you may.
Ms. Rachel Genital, can you hear me?
Yeah, I can hear you.
Did you try to call him back?
As after that, the things happened, the guy came closer to him, and suddenly a sound of someone, I think that kind of sound hears to me, that someone pumping Trayvon and yelling. And then the phone got off. After that, I tried to call him more than 3 times, but he never answered. Later, I found that he had been shot.
Okay. He never pick up your call right at the time of incidents. So may I seek permission from the ladyships, if ladyship allow me to expose the exhibit number 7s for getting more perfectly understand on the exhibit number 7, from the exhibit number 7, that what actually she want to say. May I?
Yes, you may.
Okay. Here you are, my ladyship. These are the calls has been done from the Richard janitors, but Trayvon Martin couldn't able to proceed and couldn't able to respond to the call. So what does that mean? That means she never on the life more. That's it. Okay, my ladyship, without further delay, Miss Rachel Genital, how did this incident affect you?
Yes, and Trayvon was one of my best friend, and he was not only friend to me. He's my love, and he's everything to me. He's that broke me for big side.
We understand your pain, and the core also understand your pain. And I would like to need for the co-counselor on the behalf of respondents at defense side that my co-counselor know the statutes very well. So, without further delay, why are you testifying today, Miss Rachel Janitor?
And because I want, I was the last person whom Trayvon talked, and I have experienced all that happened at that time. I beg to the court that do justice for Trayvon. I beg this honorable jury to justice for Trayvon. I want justice for Trayvon. That's all that I want. He did not
Okay,
deserve to be died like that. He
got
was
it,
a
got it.
very kind person.
And I hope the honorable court and the ladyships would get perfectly you. My ladyships, with the kind permission of your ladyship, without further delay, I just conclude my direct examinations with Rachel. You were the last voice Trayvon ever heard, right? And today your voice become his. Miss Rachel Genital, you did not just lose a friend, you lost a brother, and you lost a future partner, and the world lost a young man trying to get home. Thank you for your strength, Rachel, for standing here when it still
Thank you.
hurts. And
Thank
I got a goosebumps when I said these kind of statements to you, that how you strength and appreciate it. And for giving Trayvon the justice he can no longer ask for himself. Thank you, Your Honor. And thank you, Rachel. No further question, Your Honor.
All right, cross.
Yes, Your Honor. We have cross examinations. The defense would like to move further cross examinations, if your
Yes.
lordship allow.
Yes, you may.
Thank you, Your Honor. Mr. Gential, are you here?
Yeah, I'm here.
Mr. Gential, you referred to Trayvon as your friend, your love, correct?
Yeah.
Okay. So, Mr. Gential, so it is fair to say you had deep emotional feelings for him at the time?
Yeah, he was very close to me.
Okay. And your goal in testifying today is to get justice for Trayvon, right?
Yeah, I want justice that I mentioned earlier.
Okay, so Mr. Gential, you mentioned Trayvon was not perfect and got in trouble at school, including a suspension involving marijuana, right?
People misunderstood him. I mentioned that he was very kind. He has
Objection,
always
Yes,
my
taken care of
ladyship.
everyone.
Objection, my ladyship. It's a non-leading question. Argument.
Sorry, what are you objecting on?
It's a non-leading questions, and the attorney on the defense required to ask a leading question.
Overruled. Please proceed.
Okay. Thank you, ma'am. Okay, thank you, Your Honor. So, Mr. Gentle, please start your reply. You mentioned Trayvon was not perfect and got in trouble at school, including a suspension involving marijuana, right?
Yeah, he got suspended.
Hello.
Yeah, he got suspended. Can you hear me?
Okay. So, Mr. Jonah, Miss Jonah, were you aware of any other disciplinary issues he faced?
He was the drug marijuana had been found in his bed, but he was a teenager at that time. He never messed up with
Okay,
any other
Miss
guy.
Jonah, Miss Rachel.
He
Okay,
never shared drugs
Mr.
with
Rachel.
others.
Okay, Mr. Rachel. Mr. Chal, would you agree Trayvon sometimes got into conflicts or showed signs of anger?
No. I totally reject this person.
But you have mentioned it in your affidavit, right?
Can you repeat your question?
I said, would you agree Trayvon sometimes got into conflicts or signs of anger?
I'm saying that people misunderstood him. He was very kind and helpful guy. He never wants to get in trouble with
Yes or
others.
no?
No,
Would you agree or not?
no, he's not, but people misunderstood him.
Okay. So moving for the next question, Miss, you testified that Trayvon had said someone was following him, but he never told you the person's name, right?
Yeah, right.
And he did never say that that was George Zimmerman, right?
Yeah, right.
Okay. Miss Rachel, you were not on video call, just on audio call, right?
Yeah, I was on call. What do you call?
Sorry.
Yeah, I'm saying yes, I was on audio call.
Okay. Your Honor, the defense counsel would now submit Exhibit 7 before moving for more cross questions. If you allow, may we share our screen for the Exhibit 7?
Yes, you may.
Uh, Defense Attorney 2, please share your screen. Miss Rachel, do you recognize this document?
Yeah, it was my call records that I called to travel.
Okay. Miss Rachel, you have call with Trayvon from 7:16 to from 7:12 to 7:16, right?
Yeah,
And you don't know what happened after that, right?
sorry, can you repeat your question?
I said, and you don't know what happened after 7:16 p.m.
No, I just mentioned earlier that the call got disconnected.
Yes
And
or
I
no?
have
Okay.
tried to call now.
Okay. Mr. Miss Gentle, the call show you were speaking with Trayvon from 7:12 to 7:16. Is that accurate? Okay. Asha, Miss Gentle, are you hearing me?
Yeah, I can hear you.
Okay. So moving for our next question. You stated you heard Trayvon say, "Why you following me?" Right?
Yeah, I have heard that.
And someone respond, "What you doing around here?"
Yeah, I heard that.
Not George Zimmerman, right?
Yeah, he is not specifically mentioned in that.
Okay. Okay. Miss Rachel, you said connection got cracky, and then you heard a thump, but you can't confirm that for certain, right?
Yeah, I have heard a noise that something have
Okay.
bumped and someone has hit it Trayvon.
Okay. So Miss Rachel, you didn't hear any screams, punches, or gunshots, etc. Did you hear?
No, I got that bump voice after that the call got been disconnected.
Okay. And when the call dropped, you did not contact with police, right?
No, I didn't reach contact police.
Sorry, Miss Gentle, you are not audible.
I'm saying that I haven't contacted with police. I have tried to call
You,
Trevor multiple times,
uh,
but he never responded.
sorry. Can you repeat your question? Answer, please.
I'm saying that I have tried to call Trayvon more than 3 times, but he never respond.
Okay, I said that when he did not respond, you did not call the police, right?
No. I was in shock. I was worrying about him, so that's
O-
why that in hurry I put that thing not comes to my mind.
And even you did not inform Trayvon's family, right?
No, I haven't informed.
Sorry.
I'm saying that no, I haven't informed them.
Okay. Uh, you have said in your affidavit that you have no idea what happened next, right?
Yeah,
And
yeah,
it
I did.
means it means that you did not witness the physical altercation.
Yeah, that's right. I was on call. I haven't seen any physical. act.
Sorry.
I'm saying that I was on call. I was not. I haven't experienced any physical because I was on call.
Miss Rachel, to be clear, you didn't see Trayvon that night, and you didn't see the confrontation, and you didn't see who started it, right?
I have mentioned that I was on call. I was on call. How can I see that
I,
thing?
I'm just saying, right? Yes or no?
No, I haven't seen.
Sorry.
I haven't seen. I just heard what which I have explained.
Okay, so Miss Rachel, and you also did not see who started the confrontation, right? Na?
Yeah, I haven't. I just heard that voices. What are you doing?
Okay, bas.
After that, the call come.
Okay, thank you, Miss Rachel. Thank you. No further questions, Your Honor. Thank you so much.
All right. Any redirects?
No, Your Ladyship.
All right. Then Mr. Rachel Genital, you may step down. Let's take a 5-minute break before stepping into our defense witnesses. All right.
Sure, Your Ladyship, much obliged.
And what do you know about Zimmerman's history with law enforcement?
Zimmerman made a 46 call over 6 years, many involving report of suspicious individual, and a significant number of these calls focus on the young black males.
Okay, so on that night, was Zimmerman armed or?
Like Zimmerman always carry a firearm legally under a Florida laws, like have to it with him. He when he patrols to his neighborhood.
Okay, so let's talk about the night of incident. What happened on February 26, 2012?
As Zimmerman called the Sanford Police Department, report a suspicious person walking through the red track at Twins Lake, and the person was Trayvon Martin.
Okay, and what happened after Zimmerman's call?
After Zimmerman called, he stated that the Trayvon ran, and after that, someone called 911, and not a direct eyewitness, but just someone who heard a call and called in worry.
Okay, Miss Your Honor, I would like to present exhibit for the next question, and the exhibit number is our just 911 calls.
6.
6. Yes. Please, attorney to kindly share the exhibit 6. Yes. Your Honor, this is the call exhibit of 911 calls. So, Mr. Billy, what did 911 call contain?
And the 911 call contained a small short conversation between the caller and the dispatcher. And the call would add a screaming could hear in the background, and the call ended with a gunshot.
And Mr. Billy, what did the department do after following this incident?
Like after the incidents, we conduct a general investigation, like we test George Zimmerman guns. And we found a fingerprint and the DNA, only Zimmerman fingerprints and DNA were found on it. And the Trayvon was unarmed.
So, Mr. Willie, can you specify what did auto spy show?
Like we also investigate autopsy report, and if we can find the real and trace level of tetrahydrocarbonic THC, the primary medical agent in marijuana, in the blood of Trayvon Martin.
Okay, so did you look into Trayvon Martin's phone?
Yeah, we discovered text messages and pictures, including photo of semi-autonomic pistols and ammunitions and small marijuana plants in pots, and the picture of Trayvon making obsessive gestures. And his message also refers being kicked out of the house, and the teacher accusing him of hitting someone during a school fight.
Okay, so Mr. Willie, what did Zimmerman claim during the confrontation?
Like Zimmerman stated that, Trayvon initiated physical altercations during which Zimmerman discharged his firearm in self-defense.
Okay, and did your department believe there was enough evidence to arrest Zimmerman?
Yeah, we do not have enough evidence to concrete and arrest Zimmerman. So initially, we closed the case with a backlash from my co-worker.
Okay, Mr. Willie, one last question from my side. Was there any criticism about the handling of case?
Yeah, I faced a significant public criticism later, especially when many in the community believed that the department decision not to arrest Zimmerman was influenced by his further position as a retired magistrate.
Okay, Mr. Willie, thank you so much. No more questions, Your Honor. Thank you, Mr. Willie.
Okay, cross.
With the kind permission of your ladyship, may I proceed the cross-examinations with Chief Billy?
Yes, you may.
Much obliged, your ladyship. Can you hear me, Chief Billy?
Yeah, I hear you.
And I hope I get the Sam good name. You are Billy, right?
Yeah, I am.
Okay. Chief Billy, on the night of February 26, 2012, despite the fatal shooting of an unarmed teenager, you choose not to arrest George Zimmerman, correct?
I don't understand your question. Please rephrase it.
Sure. Chief Lee, on the night of incident, despite the fatal shooting of an unarmed teenager, you choose not to arrest George Zimmerman, correct?
Yes, because we don't have any concrete evidence. That's why we close the case.
Okay, point to be noted, my ladyship. The Chief Billy has no concluded evidence. Next question without further delay. Isn't it true that your lead investigator, Chris Sereno, recommended that Zimmerman be charged with manslaughter, yet you did not act on this recommendation?
Sorry, I don't get you.
Okay, I would repeat. Is not yet true that your lead investigator, Chris Sereno, recommended that Zimmerman be charged with manslaughter, yet you did not act on this recommendation?
Objection,
Yes or
Your
no?
Honor.
What grounds?
Compound question.
My ladyships, I would respond in the term of this is not a compound questions. This question addresses internal departmental recommendations and the witnesses' response.
Can you rephrase your question? Judge will decide itself, is it compound or not?
I will sustain. Please break down your question.
Thank you, Your Honor.
Without further delay, Chief Billy, can you hear me?
Yeah, I hear you.
Thank you. You were aware that Zimmerman had made numerous calls to the police reporting young black male as suspicious, weren't you?
Yeah.
Yeah, okay. And despite community concern about Zimmerman's behavior, you did not take any action to address or investigate these complaints, did you?
We did. We investigate. Like 4 of them were unarrested, by like 42 we don't have any.
My ladyships, try to. I would like to draw the kind attentions of your leaderships towards that Billy is emphasizing that he did investigate, but in the prior questions he said that he has no conclude investigations. That's it. And
Like
the
I
next
said,
questions is
don't.
you advise against playing the 911 call to Trayvon Martin's family as a group, yet city official proceeded without your presence, correct?
I don't understand your question. Please rephrase it.
You advised against playing 911 call as you also early exposed the exhibit 911 call one to Transmotor family as a group, yet city official proceed without your presence, correct?
Objection, Your Honor.
On the grounds?
Your Honor, the opposite counsel is bargaining. This is not clearly asking the questions that manipulate facts, ITC.
May I?
Response?
It's a clear questions, my ladyships. This questions pertains to procedural decisions, and I am front of a Chief Billy, a Sanford Police Department. So the witness professional input I'm asking about, which are relevant to the case.
Response from attorney. Response from defense. Wait, are you objecting on relevance?
Your
They are
Honor, I'm
checking on the-
objecting for bargaining the question. The question is being mixed with things
my question
not clear.
was, may I? My question was so simple. It was I advise against playing the 911 call to Trans Martins.
Can you rephrase your question? What
Sure.
did you say before?
Sure. You advised, Chief Billy, can you hear me?
Yeah, I can.
You advise against playing 911 call to Trayvon Martins. Yet city official proceeded without your presence, correct?
No, I don't get your question. Like, what are you saying? I don't understand.
Your
I'm
Honor, he
saying
has rephrased the question until yet it is not understandable.
it's not the attorney faults. My question is so simple. It's about the 911 call exhibits, right? I say that you advised against playing the 911 call to Trayvon Martins, yet city official proceed without your presence, correct?
Like, it was not written in my affidavit. I guess you are asking out of the court statement.
It's not out of, it's a procedural decisions and witness professional inputs.
You are going out of the affidavit. I guess it is not written in my affidavits.
My witness, I'm really sorry, with all due respects, you are not supposed to sing like that. The attorney should.
What are you doing?
Okay. Let's all stop. There are a lot of problems here. So, first of all, I think prosecution counsel, you need to make your questions simpler. The
Okay.
question just asked
My question is, yes, ladyship, my question is totally about the procedure.
Sorry,
that
has lost his connection. She is going back.
Okay.
Kindly let
so
us know if when you feel comfy.
let's wait for Chief Billy to come back, and then I'll say this stuff.
Sure, much obliged.
So sorry for inconvenience. So sorry.
No, it's okay.
Okay, so first of all, prosecution attorney, you need to break down your questions because the question that you just asked is a compound question, and it's way too long. And second of all, Chief Billy, if the thing that he asked did not appear in your affidavit, just say I don't know. Okay. All right, let's proceed.
My ladyships, I hope the witnesses is not cooperate with this question, so I may proceed with the further question.
All right, let's move on.
Okay, you stated that there was pressure from city official to make an arrest, but you still choose not to, correct?
No, I don't know. about that.
Okay. And your decision not to arrest Zimmerman immediately after the shooting led to public outcry and your eventual resignation, didn't it?
No, I have no idea about that.
I didn't get you. Yes or
No,
no?
I don't know.
You don't know?
Yeah.
Okay, point to be noted, my leadership. My last question is, you would agree that the failure to arrest Zimmerman immediately after the shooting undermined public trust in the Sanford Police Department, wouldn't you?
No, I don't know.
Okay, you don't know. That's all from my side, my leadership. That's all from my side. Much obliged for your time.
All right. Any redirects? Defense, any redirect of Chief Billy?
No, Your Honor. I have no redirects. Thank you so much.
Okay, then we can move on to our second defense witness.
May it please the court, I want to present my second witness, the accused Mr. George Zimmerman, in the court. May I?
Yes, you may.
Mr. George, come before the stand. Mr. George, firstly make a oath. I will speak and repeat before me. Okay? I solemnly affirm Mr. George, turn on your mic, please.
I'm audible.
Thank you. Yes, now you're audible. So, make oath. I solemnly affirm
I solemnly affirm
I will speak truth,
I will speak truth,
speak truth, and nothing will conceal.
and nothing will conceal.
Thank you. You may sit now. So, Mr. George, are you comfortable with the environment of court?
Yes.
Okay. Your Honor, may I proceed with my direct examination?
Yes, you may.
Thank you, Your Honor. So, Mr. George, would you please state your full name and spell for the record of the court?
Hello, my name is George Zimmerman, Zimmerman.
So, Mr. George, is it okay for me to call you the George?
Yes, it's fine.
Thank you. So, Mr. George, tell me little about your childhood.
There's quite a lot to tell. Let's see. There was a lot of church. I love spending time there. It taught me to care of my community and for everyone that is around me. However, that was not a skill that helped me deal with all the kids that bullied me in school. They would pick on me, very often, and sometimes I would stand up for myself like every normal person.
So, Mr. George, you stated that stand by yourself. Tell me more about what do you mean by stand by yourself?
There is something I'm not proud of. I once got in a fight with a kid at my school. Actually, quite a few of them were African American. I never understood why they would pick on me. We were both from a minority, and we all know the pains of this life. It is not like I was like living a lavish childhood. But as I was saying, I would sometimes get in a fights when I would get sick of having people bullying me. This is, I will say, cultivated as much paranoia in me as it taught me to stand my ground and learn to defend myself.
Perfect. So that's why you want to become a police officer?
To some extent, I suppose I have just always believed that I'm meant for this job. Defending the public and also putting my senses of anger to use, all that called on me. It is like a job in summing me, but sadly, they still have not accepted me as a cop. Sometimes that brings me great amount of pain.
Oh, so sad to hear you. So what was your reaction to that?
I created as a neighborhood watch captain. I figured if I can't be a policeman, at least let me help those closest to me. I went through a official training and everything to become captain.
Your Honor, may the record state the defense is sharing their screen. May I?
Yes, you may.
Thank you, Your Honor. So, Your Honor, I want your attention towards the Exhibit 4.
Mhm.
So, Mr. George, do you recognize the document?
Yes.
Do you believe it authentic?
Yes.
Has it been altered in any way?
No.
Your Honor, I would like to introduce Exhibit 4 in the evidence.
Any objections? Prosecution, any objections? Hello? Prosecution, any objections on entering this exhibit into evidence? Prosecution attorney, please respond.
With all due respect, I hope there's some network issues to the attorney first. So it's a humble request to the court. Just give 2 minutes if you don't mind.
Okay, let's wait for the attorney to come back.
Okay, Your Honor.
Is she back?
Your Honor, may I proceed?
Wait, I don't think the prosecution attorney's back yet.
Okay, Your Honor.
Prosecution attorney, do you know when your co-counsel is gonna be back?
Without further delay, we are not getting too much time. So it's a humble request to defense attorney second may proceed. If you allow, if judge allowed.
Okay, then do you have any objections on entering this exhibit into evidence?
We do, but my co-counselors just send me one photo of their own that she is just facing a network issues and entering in the room, so that's why she couldn't able to do that. So
Okay, let's wait for her.
thank you, much obliged.
Unarmed, wasn't he?
Yes.
Point to be noted, my lord. Trayvon Martin was a mere teenager and he was unarmed as well. You refer to Trayvon using expletives in your call. Did you?
Sorry, attorney, I didn't get question.
You refer to Trayvon using expletives in your call. Did you?
Attorney, explicit word.
Let's move to the next question. Isn't it true that you created and lead your own neighborhood watch, appointing yourself captain?
Yes.
Okay. So you claim self-defense, but you initiated the pursuit. Where was your fear then?
No, it was all self-defense. As I mentioned, that he was the one who started hand on me.
But you followed him, you scared him, he was terrified, and you pursued him first. How can
Objection,
you
Your
say
Honor.
that it's a self-defense?
Objection, Your Honor.
Oh, what? I don't think you're allowed to object. You need to let your co-counsel object.
Okay, legal, please.
So, are there any objections?
Yes, Your Honor. The counsel is trying to ask and answer the questions.
I'm
And
just
it is
trying to-
argumentative.
Sorry, I couldn't hear.
Your Honor, counsel is making argumentative questions. My witness already answered.
Counsel, can you repeat your question that I just asked?
Okay. So I asked the question. George Zimmerman claimed self-defense, but he initiated the pursuit. And where his fear was at that time, he said he attacked Martin and he shot Martin in self-defense, but he followed him and he pursued him first.
Yep.
Then how can it be a self-defense?
Okay, I'm gonna sustain the argumentative objection. Please proceed.
Your Honor.
Okay, moving toward the next question. So you pursued an unarmed teenager with a loaded weapon against police instructions. Is it correct?
Well, I took my gun just to get the thing that not go nasty.
I'm asking you, is it correct?
Yes.
Point to be noted, my lord. Trayvon was unarmed and he was a teenager. But Zimmerman had a loaded gun and he was an adult. He had a choice. Okay, you mentioned in your deposition that you often reported blackmails to the police, and can you explain why race was relevant to you to your suspension?
Well, I don't believe so. It's a pattern recognition.
Can you repeat your answer?
Well, I don't think so, attorney, but I believe it's a pattern recognition.
When you said those assholes get away, who were you referring to exactly? What do you mean by those?
Well,
Your Honor.
Objection, Your Honor.
Again, only one person can object. And on what grounds?
Your Honor, counsel is trying to ask the compound questions and two lengthy questions. And also my witness already answered those questions.
Okay, I will sustain the objection. Prosecution attorney, please break down your questions.
When you said those assholes never get away, sorry, those assholes get away, who were you referring to exactly?
well, I didn't refer to exactly the exact name, but I was just mentioning it due to my past experiences that were bullied on me. You said those. And I believe it's a plural word, not a single word. Okay. So, you were accused of domestic violence by your fiance in 2006. Is it correct? Yes, but the things I got your point. So, you assaulted a policeman in 2005. Is it correct? Yes, I was drunk. Okay, I got your point. You said Trayvon Martin bashed your head against the pavement, yet Trayvon had no weapons and no offensive words. Isn't that correct? Well, he hand on me and start bashing my head on pavement again and again and again. And but you can followed see him? That. You followed him first? I followed him. I followed him. Yes, I followed him. But then I went back to my car when I've seen it's not a danger. Okay. Over a damaged package, even after your neighbor said nothing was broken. Is it correct? Yes. Okay. So, would you agree you have a history of overreacting to minor situations and escalating conflict? I don't believe so. But you have a history. We have evidences that you assaulted a policeman in 2005 and you were accused of domestic violence also, and you also threatened the mailman. Well, that doesn't mean that I have a history of overreacting. That is all according to situation. Okay.
Objection, Your Honor.
On what grounds?
Your Honor, counsel is making a hearsay statement speculating the fact without exhibiting the evidence before the court.
I will overrule this. Please move on.
May I show the evidences?
Sorry, what?
May I show the evidences?
Oh, yes, you may. Yes.
Before showing the evidences, I would like to say that George Zimmerman in his deposition said that yes, he was accused of domestic violence and he had a previous history of committing assaulting people and threatening, and I was referring to those evidences. And it's not a hearsay statement.
Oh, I already overruled the objection. You can just move on with your cross.
Thank you so much. So there is no need to show exactly the deposition of George Zimmerman. May I go ahead?
Yes, you may.
Okay. So that's all from my side.
Okay, any redirects?
Yes, Your Honor. May I?
Yes, you may.
Thank you. So, Mr. George, did you have any examples regarding that you are not a racist? Can you tell the court?
Yes, certainly.
Thank you.
I already mentioned that I myself belong to minority, and I know the segregation of this. And even though I voted Obama in 2008 as well.
And Mr. George, after your probation period, when you clear, you do not have any incidents of assaulting someone. Am I right?
Yes, certainly.
Thank you, Your Honor. So, Your Honor, here I'm leaving my witness again. Thank you.
All right. Any recrosses?
Yeah. You claim Trayvon jumped you, yet you admit he asked first, Why are you following me?
Yes.
Okay. So,
Objection, Your Honor.
On what grounds?
Your Honor, counsel can cross again after what I said in my redirect. Not again. It is wasting the time of court. Time's up.
Sorry, are you saying that the recross is not according to what you said in the redirect?
Yes, Your Honor.
All right, sustained. Please, for the recross, please, just talk about what is mentioned in the redirect.
okay. So, we have an affidavit of Ms. Simon. She said, after her documented analysis, that George Zimmerman showed a behavior based on bias and racial.
Objection, Your Honor.
On what grounds?
Your Honor, counsel cannot ask any other witness statement to Mr. Zimmerman. He is not bound to answer on those speculations.
I'm just trying to show the facts and the evidence. And I'm saying that George Zimmerman was a racist, and here is a proof. And as we had an expert, Miss Gina Simpson, and she explained it in his affidavit that George Zimmerman called while confronting the Trayvon. He said, "Those assholes never get away," and this is a statement that shows the racial behavior of George Zimmerman.
Any response?
Your Honor, I will say again that counsel can ask from the deposition question, but cannot ask the statement of any other witness to the Mr. Zimmerman.
I will sustain the objection. This is not allowed. Other witnesses' affidavits is not allowed to present in court. So please take it down.
So, Mr. George Zimmerman said in his deposition that this was my opportunity to take action, and there was no way the neighborhood watch captain, was going to sit here and watch this threat of a man crawl through my
Objection, Your
community.
Honor, again.
This is from a deposition of George Zimmerman, and he thought he was the judge and the jury.
Objection, Your Honor.
He tried to confront, and he didn't follow the policeman's instruction, and he confronted and followed and shot the victim.
Okay, defense attorney, on what grounds?
Your Honor, firstly, the counsel is asking two lengthy and compound questions, and secondly, you already stated that defense attorney can only ask the question that I ask in redirect, not recross examination. Ask the first cross examination questions again.
Okay,
I have not asked any question. I'm referring to a proof and evidence that George Zimmerman had said in his deposition. I have not asked any question.
Okay, first of all, I will sustain the objection. Second of all, even though you're not asking any questions, you're still referring to things outside of what's mentioned in the redirect. Therefore, that's not permitted in the recross. Please just mention the things that are mentioned in the redirect.
Okay. So, shall I begin to the question?
Yes, you may.
So, Mr. Zimmerman, you said in your deposition that this was my opportunity to take action. What does it mean?
Well, I mean that it was the time to save the community. on my behalf.
Okay, so that's all from my side.
All right. Any redirect?
No, Your Honor, that's all.
All right, then we can proceed to closing statements. Prosecution, closing.
Yes, Your Honor.
You may proceed.
With the kind permission of Your Lordship, and without further delay, may it please the court? Can you hear me?
Yes, you may proceed.
Much obliged. My ladyship, I want to realize that to the court, we are gathered here today because a 17 years old child, Trayvon Martin, is dead. He was walking home from the store with a drink and candy, unarmed and not a threat. But because of George Zimmerman's assumptions and choices, Trayvon will never return home, my ladyship. Trayvon will never return home, my ladyship. George Zimmerman is not on trial for being a part of Neighborhood Watch today. He is on trial for ignoring the 911 dispatcher who told him not to follow, just get in the car. Why are you following it? And beside that, he had a choice, he had options, but he chose violation, and he get out the car and stalking the victim called Trayvon Martin. My ladyship, I would like to draw the attentions toward that how could be worse than this to a 17 years old boy when someone a 35 up to 40 years old is stalking him. So how would respond at that hold? They would respond that hold to cover up himself and then keep away and get away. That's it. And he is on trial for getting out of his vehicle, confronting Trayvon, and making a fatal decision. My ladyship, this case is not about what Trayvon could have done. It's about what George Zimmerman did. He pursued, he escalated, he pulled the trigger. The defense argued that Trayvon had THC in his system. Yes, I know, my ladyship, the THC in his system mean in his blood. I would like to draw the kind intentions toward that the expert also mentioned that the marijuana was found in his blood system is totally 1.5 nanomilliliter. Correct me if I'm wrong, other defense side. 1.5 nanomilliliter, and his expertise said with the side of expertise that 1.5 nanomilliliter of cannabis of marijuana could not affect the health, could not affect the decisions. But who does not mess up? I would like to convince again the attentions that who does not mess up in the teenage year, my ladyship? But let us be guided by the expert Dr. Gina Simmons, whose forensic affidavit is crystal clear. Your ladyship, at lines 118 to 121, she states the THC level in the Trayvon Martin's blood was 1.5 nanogram per milliliter, a dosage so low that would not have affected his cognitive ability. In fact, only 1% in peer-reviewed studies ever show minimal impact at that dosage. Therefore, my ladyship, this is not about impairment, your ladyship. It's about a scared teenager being followed and ultimately shot. by an armed adult who choose confrontation or cautions? As per the expertise said, after the forensic of the George Zimmerman and a forensic data said that there was fingerprints on the gun of the George Zimmerman, not the Trayvon Martins. So it's a humbly request and I humbly submitted that here who is the victim and who is the accused, offender. Rachel Genital, Trayvon's close friend, my ladyship, testified that Trayvon was terrified. She said he told her, if you don't mind, as I quote what mentioned in the affidavit, that she said he told her, this creepy dash cracker keep following me. He was out of breath, scared, and trying to go home. She heard Trayvon ask, what are you following me? Why you are stalking me? That is not aggression, my ladyship. It is fair. It is self-preservation. George Zimmerman had the training. George Zimmerman had the weapon. Trayvon Martin had candy and a drink, not a weapon in his hand, my ladyship. The weapon was already totally in hand to the George Zimmerman. So, your ladyship, there was only pursuit, and then a short Florida law does not protect vigilantes. I would like to draw the kind attentions toward the word vigilantes. Florida law does not protect vigilantes. It protects victims, my ladyship. Protect victims. George Zimmerman provoked. George Zimmerman escalated. George Zimmerman killed. And he must be held accountable for the death of an unarmed child. Therefore, your ladyship, and we respectfully submit that George Zimmerman is guilty of manslaughter, and justice demands a verdict that reflects truth, reason, and the value of a young life. The value of a young life, my ladyship. That's all from my side. Thank you. Much obliged for your time.
All right. Closing from defense.
May it please the court. May I proceed with my closing statement?
Yes, you may.
Members of the jury, the case is about the tragic loss of the life. More importantly, it is about the application of specifically law on self-defense, Florida law, statute 776.01, which state that self-defense is allowed when there is imminent threat is there, when your life is in danger, and when it is necessary. So, Your Honor, in a present case, yes, the imminent threat is there. It is a necessity. Your Honor, my client, Mr. George, already stated that Martin pulled down and slapped his head. Because of that, he cannot understand anything. He did what he can do for the sake of his life. Your Honor, additionally, I want to say that the burden of proof lies on the prosecution to prove that Mr. George is not acting in a self-defense. But, Your Honor, I am sorry to say that prosecution fails to do so. Prosecution presented two witnesses. Witness one, that is Gina Simon. Your Honor, Mr. Gina Simon, who testified as a competent witness, as an expert witness, as a psychologist, but her credibility is that he is testifying before the court first time, and also before the court first time in a criminal cases. Your Honor, he also admitted in his cross-examination that yes, he is a therapist for the family cases. He is a counselor, but not for a criminal cases. On his credibility, he just have a research article on criminal profiling, and also he admitted that he never met my client, Mr. George, and also he was not present on that night. So, Your Honor, his whole testimony is based on presumption. He also, at the end, admitted that it could be a possibility that Mr. Zimmerman is acting in a self-defense. So, Your Honor, when there is a possibility, so of course the doubt is here, and prosecution failed to prove his case beyond the reasonable doubt. And Your Honor, it is admitted under the law that the benefit of doubt do not given to the prosecution, but to give the innocent person, the accused, for because of that, the prosecution is making allegations on that person. Your Honor, also, prosecution presented his second witness, Mr. Richard Janitor. Your Honor, I want to quote the facts quoted in Exhibit 6 and 7, which is admissible before the court during our direct and cross-examinations. Your Honor, in Exhibit 6, the call record of Mr. George to the police, which shows that on 7/16, Mr. George is on the call with the police. And also Exhibit 7, which shows that Mr. Richard is on call on same time 7/16 with the Mr. Martin. Your Honor, how could be possible that one person is in the car, because it is admitted fact and prosecution admitted that when Mr. George is making a call, he is in the car. So, Your Honor, how it could be possible when a person in a car and at the same time follow the person? So, Miss Rachel's whole testimony based on his out of affection with the Mr. Martin, because he admitted that he has good relationship with Mr. Martin. His whole testimony is to emotion, but Your Honor, law does not believe on emotion. Law believe on facts, on law specifically. Your Honor, also prosecution trying to mislead the court and trying to make presumption before the court and speculative the facts. Your Honor, he made argumentative statements again and again, although they asked the out of court statements. Your Honor, Mr. Chief Billy stated in his examination that concluding evidence for arresting the George Zimmerman is not enough. They did not say that concluding evidence is not enough for taking the plea of self-defense. Your Honor, I want to make correct. And second thing, Your Honor, I want to quote the case of Bruno Software Co. versus the Mars investigation 1998. Your Honor, in this case, court held that the counsel cannot use his expert witness as a weapon, and they cannot give his opinion and make presumption before the court. But Your Honor, we all observed eyewitnesses that Mr. Simon continuously making speculations, making presumptions. Oh, because he is neither present at the scene, he is neither met with the Mr. Zimmerman. He never conducted the interview. His whole testimony is based on what he perceived, what he got from online website and theories, and he quoted some theories, and also he admitted yes, implicit biases are there. Your Honor, it could be a possibility that Mr. Zimmerman is acting because be a bias because he is getting benefit. He admitted in his cross-examination that he is getting a remuneration for testifying in a on a behalf of prosecution. My second point, Your Honor, that my respected prosecution counsel stated in his closing statement that in Martin's blood 9.9 liter. Your Honor, point to be noted that 9.9 liter marijuana exists. If a person who is under 18 and 9.9 liter marijuana exists in his blood, how can be he so vigilant on that time, Your Honor? So it's clearly stated that he is not a vigilant on that time. But if Your Honor, we look at the exhibit that are admitted before the court in Exhibit 5 specifically, in which the test of Mr. Martin is there. So even though relying on that exhibit, we can say that Martin is under 18. Why? If he take such dose of marijuana THC, he can act negligently. He can act irrationally. So, Your Honor, in that way, my client is acting in a self-defense. Again, as I reaffirmed in State versus Ross 2001, once self-defense the race, prosecution must disprove it beyond the reasonable doubt. I again want to make it clear that prosecution did not prove his case beyond the reasonable doubt. And also in whole his trial, prosecution tried to make the speculation, manipulating the facts, but at the end, what the result is that prosecution failed to prove his case beyond the reasonable doubt. And in the light of all my arguments, I want to pray that please, therefore, respectfully ask you to return a verdict and declare our client is acting in a self-defense, it is not an intentional murder. Thank you, Your Honor.
All right. Rebuttal from the prosecution?
No, Your Ladyship. That's all.
Okay. Give me a few seconds to write down my comments, and then I'll give some comments to you guys.
Sure, Your Honor.
Hello, just a self-introduction. My name is Corrine Jhang, and I started doing mock trial last year in April. So I have around over a year of mock trial experience. I've captained some international mock trial competition teams, some LACA teams, and I also did some Empire competitions. So I do kind of know how this mock trial thing works. So first of all, I would say very well taken on both sides. This has been a very great round. But some major issues that I'm noticing throughout the trial is that a lot of attorneys, you guys are oftenly interrupting the witnesses or the opposing counsels, and this goes more to judge preferences. But personally, I don't like attorneys who interrupt and badger others. So for example, when you're doing an objection, you need to wait for the opposing counsel to finish what they're saying and then continue on your response, other than just to, talking over each other. Because that way I really can't hear anything at all, and it does not help you at all. So yeah, that's one of the major issues that I'm noticing. Let's see. Anything else? I think in general, the witnesses, you guys need to have a bit more character. I see that the defense witnesses, you guys have a outfit, a costume. I think that's really cool. That's something definitely the prosecution side witnesses can learn from. Actually, I also did the George Zimmerman case in April, and I also had a costume. I can show you guys a picture. Yeah, so I was George Zimmerman in the LACA April. So I was a witness, and this was my costume. I don't know if you guys can see it, but basically, yeah, I had a cast for my costume, and I think that's something that you guys can definitely implement, just so just to have a bit more character. So yeah, that's just some general comments. I have more specific comments in the ballots that you guys can see later. So do you guys have any questions?
Yes, I want to just say if you specifically give remarks because we have a second round after this, so we can
Oh,
improve those mistakes.
okay. Actually, I wrote quite a lot. Give me 1 second. I can just send the PDF file in the chat box and you guys can read it yourselves. Is that okay?
I think, but it is not allowed.
Oh. Because it's gonna take a lot of time for me to say everything, honestly.
Oh, so it's okay. No
Give me
issue.
1 second. It's fine. I'll just share my notes.
Do you have any suggestion for prosecution?
For prosecution, I think you guys, let's see. I think you guys should learn not to interrupt witnesses and attorneys when during cross-examinations and also during objections. But like other than that, I think you guys are pretty good, honestly. So yeah.
Thank you.
All right. So these are my notes. It's fine, just read them.
So I'm
And-
audible?
Sorry, what?
I'm just asking, can you please give a review on me that as a George Zimmerman, what kind of improvement I should do for my next rounds?
Oh, I think during your cross-examination, I remember you not being really fighty when they are asking some very important questions. So personally, when there are questions that really hurts you or really hurts your team, you should definitely fight more. That's one of my general comments that I think you should improve on. Because like most of the time you were just answering yes or no, or like that kind of stuff. And you can be a bit more specific on, why this is a no, why this is a yes, and just generally just fight more. So yeah.
Okay. My question is regarding witnesses that if a witness has been asked a leading person, how he respond? He is allowed to explain the facts or he just say yes or no and pass on to the next person.
Sorry, I can't really hear you. Can you repeat your question?
I'm asking about, am I audible to you?
Yeah.
Okay, I'm asking regarding the witnesses that witness in while doing cross-examination, there are mostly leading questions. He has to just say yes or no. If the witness is allowed to explain the facts or not, I want to know these things.
Oh, the witnesses are definitely allowed to explain the facts. So there's this thing called the yes sandwich in cross-examination that I think all witnesses should use. So basically, it's like this. So when the opposing attorney asks a question, you sometimes just say yes. But then after saying yes, you elaborate on why this is a yes, or if why is there an alternative explanation, but like you end with your response but that's a yes to a question. So an example of how this works is like, yes, Trayvon Martin did have some THC in his blood. However, that does not really affect how he works and how he functions as a person, but that's still a yes to a question. There is THC in his blood. So if you respond like this, you do answer the question in the yes or no format, but you still have your grounds stated. You still have your explanations stated in your response.
What if the attorney is not allowing us to speak? Like he is interrupting the witness. He's saying that just I want to know yes or no. How then the witness should respond?
Because like you just say that's a yes to a question. The yes sandwich, the last part of the yes sandwich, that's a that's like answering the question. That's a yes. So like, if you answer it like that, then the attorneys can't really say anything. Does that make sense? Because you did answer their question.
Okay, so we are allowed to explain the facts then, or we are saying yes.
Sorry, what?
I'm saying that if we say yes or no, we are allowed to explain the facts
Yes, you are.
after
You are.
that.
You're
Okay.
allowed.
Thank you so much.
Any more questions? If not, I think you guys are free to go.
Okay, thank you so much. It was very nice. So, so still I'm asking this question. What will be your verdict if you have to decide this case after this trial?
This is really hard to decide.
Based on trial, what will be your verdict?
I'm probably gonna say George Zimmerman's not guilty.
Okay.
Yeah.
So I have to worry for that. My friend have not been the justice.
Very well fought on both sides. You guys are very amazing. Yeah.
Thank you.
Yeah. Have a good day. Good luck in your next rounds. Good luck. All right.
Thank you
Bye.
so